Good afternoon. We thank you for joining us today. A few of us have some concerns with the UN Convention on the Rights for Persons with Disabilities. We understand that this is an emotional issue for many, and it is an important issue. We here in the United States have the most robust set of laws designed to protect persons with disabilities of any country that I know anything about. And our concerns with this convention have nothing to do with our any lack of concern for the rights of persons with disabilities. They have everything to do with protecting U.S. sovereignty, protecting the interests of parents in the United States, and the interests of families. I have two concerns that I'd like to touch upon briefly before I turn the time over to my friend Rick Santorum. And those deal with Article 7 and Article 7 and 4 of the Convention. Article 7 contains language that would incorporate the best interests of the child standard potentially into domestic law through this UN Convention. And it would do so in a way that would create a lot of uncertainty and potentially some harm for families, especially families with children with disabilities who want to make their own decisions regarding the proper course of action to take with regard to the education of their child. The best interest of the child standard is a fairly well-worn principle of law that dates back many decades, in some respects centuries, in the Anglo-American legal jurisprudential tradition. And it is invoked only in relatively limited circumstances. Circumstances, for example, in which there has been a dissolution of the parent-child relationship and the court has to decide what happens to the child, where the child goes. The court, under our system of government, in all 50 states and in the District of Columbia, does not have plenary authority to just decide what's in the best interest of the child. Article 7 of this convention would at least create grave uncertainty as to when, under what circumstances, and to what extent the best interest of the child standard should control parental decisions regarding the education and the care and the treatment of the child. And on that basis, I oppose it. I'm also very concerned with Article 4 of the Convention. In Article 4 of the Convention, states parties that sign on to this and that ratify it embrace something known as economic, social, and cultural rights under the Convention. Economic, social, and cultural rights refer to something that is unknown in our legal system in the United States today. These rights refer to positive rights as opposed to negative rights granted by government. These are positive rights to certain entitlement obligations, certain entitlements that the government would be required by treaty to provide for individuals. We don't have this in our legal system today. And it's on this very basis that other UN conventions, other UN treaties have in the past been rejected. Because many decades ago, economic, social, and cultural rights were embedded within other UN documents. The U.S. regarded those as part of a march towards socialism and refused to embrace them on that basis. So it is with grave concern for sovereignty that I oppose this UN treaty. I will do everything I can to block its ratification. And I have secured the signatures of 36 Republican senators, all of whom have joined with me in saying that we will oppose any ratification of any treaty during this lame duck session. So with that introduction, I will turn the time over to my good friend, my friend, the former senator from Pennsylvania, Rick Santorum.
Thanks, Mike. Thank you very much, Mike. And it's interesting to be back in these surroundings again. It's been a while since I've been in the Senate hearing room, which is actually right down the hall from my old office, which is over in the corner. Joining me here are my wife, Karen, and 3 of our 7 children. Daniel, who is a senior in high school, Sarah Maria, who's a freshman in high school, and our yet-to-be in school little girl, Isabella. And Isabella is our youngest child. She is a special gift to us, and we don't often bring Isabella out for any types of public events. But Karen and I felt very, very strongly that as mothers and a mother and father of a disabled child, that we needed to speak for those in the disabilities community who have grave concerns about this convention. As Mike said, there is much to commend this convention. There are wonderful language in the convention that talks about equality and the ethical treatment of all people with disabilities, which I warmly support and continue, obviously, to support, irrespective of my opposition to this convention. But there are some very, very troubling provisions that could open up Pandora's box that could directly affect many families in America, particularly children with children who have disabilities. Mike mentioned Article 7. That is my grave concern here. As I said before, there are a lot of wonderful things written in this convention that broadly applies to people who are disabled. Why they felt compelled to write a special section on children was something that I found troubling. If they do, under this convention, set forth a panoply of rights, all of which, with one exception that Mike noted, I find support for. Why did they have to then go one step further and have a special section on children with disabilities? That raises concerns, particularly when you look at the standard that is applied, and that is the best interest of the child as determined by the state. Isabella Maria is a miracle. She was born with a condition called trisomy 18. Look it up in the medical literature. It will say these words: incompatible with life. That is her diagnosis, and is the diagnosis that is accepted across the medical profession. It is why Karen and I, on a routine basis, receive calls from moms and dads of children with trisomy 18 pleading for us to help them get care for their children, because the medical community doesn't want to provide care because these children are not supposed to be alive. These children are children who are incompatible with life. Imagine a situation if now the state, those who are not the parents of these children, have the determination as to what is in the best interest of the child. The best interest of a child who's incompatible with life seems to be something incompatible with the way Karen and I view Isabella's life. And so this is a direct assault on us and our family to hand over to the state the ability to make medical determinations and see what is in the best interest of the child, and not look at the wonderful gift that every child is and give every child the opportunity. Do I believe that states will pass laws or have to pass laws in conformity with the UN edict to have the state have the best interest of the child? Do we have to amend IDEA? I don't have any fear anytime soon that IDEA will be amended, but I do have concerns that people will go to courts and they will use this standard in this convention and through the court system begin to deny parents the right to raise their children in conformity with what they believe is in the best interest of their child. And I know there are other moms here who have children with disabilities who were counseled the best advice, which is, you know your children better than anybody else. Fight for your children. Well, that's what I'm doing. That's what Karen and I are here today doing. We're fighting for Bella, but we're fighting for the other children across this country who, in a well-meaning moment, I know Senator Reid says he's going to bring this convention up this week, in a well-meaning moment trying to look like we're doing things to help people with disabilities. As I think Mike Ferris, who I'm going to introduce in a minute, will tell you, we already have laws that protect everything that is in this convention. We already meet or exceed what this convention calls for. There's no benefit to the United States from passing it. There's no benefit to any children here in the United States from passing it. But what it does is open up a Pandora's box for the most vulnerable among us, children with disabilities. And that's why I am proud to stand here with a great United States Senator, someone who I've got a tremendous amount of respect for, and has the courage to stand up on an issue that doesn't look to be particularly popular to be opposed, and understand that while there are some good things, there are some fatal poison pills. There are flaws in this convention that require it to be defeated. So I want to just thank Karen and the kids for coming here today to join us, and I'm now turn it over to a person who has been a leader in standing up for the sovereignty of our country, someone who is a great scholar in his own right, as a lawyer and constitutional law scholar, President Patrick Henry College, as well as the head of the Homeschool Legal Defense Association, a good friend, Mike Ferris. Mike?
Thanks, Rick. Thank you so much, Rick and Senator Lee. I appreciate the opportunity to be here today. On behalf of 9,600 parents of disabled kids who signed a petition in the last week urging the rejection of this treaty, I come today to add my voice to those who are concerned and oppose the ratification of the treaty. On a very basic premise, I would assert this: Americans should make the law for America. We do not need international organizations telling us what the domestic law should be of this country. I teach international law at Patrick Henry College ever since I finished my LLM in that subject from the University of London. And the class of treaties that this nation was founded upon was how nations treat other nations, not how nations govern their own internal policies. And when we start adopting treaties that deal with the subject of how America governs its own policies, it is a fundamental violation of the principle of American self-government. Americans should make the law for America. And those who don't feel up to the task of passing American law for American children, for American families, for Americans with disabilities, ought to do the honorable thing and resign from their offices and give them over to people who feel up to the task of passing American laws to protect American children, to protect American citizens. I want to illustrate the Article 7 concern that Senator Lee brought up. In New Zealand, which is a state party to the Convention on the Rights of Persons with Disability, the homeschooling law that's there for normal, quote-unquote, children is about the same as you'll find in many American states. However, when it comes to children with disabilities, the statute reads in its one-sentence provision, and I'm paraphrasing it very closely: the Secretary shall decide in his sole discretion whether home education or public school instruction is in the best interest of the child. It employs the exact standard of this treaty and gives the government the unilateral ability to decide where this child is educated. That is the concern that has led to so many homeschooling families, so many families with disabilities, to rise up in arms about this treaty. No matter what people's intentions are, we have to realize that this is not an altruistic statement. This is not something you congratulate a former senator with, as so much of the testimony in the Senate Foreign Relations Committee was about congratulating people for their past work on this or that. A treaty is part of the highest law of the land under Article 6 of our Constitution, and it has legal effect. If no other legal effect, it has this effect. It transfers all jurisdiction on compliance with the treaty away from the states, where they normally have subject matter on education, for example, to the United States Congress. So it has effects. It has effects in many respects, but the effect that the families fear most and have risen up in arms about is the Article 7 provision that would implement the standard that you see in New Zealand law. The government would obtain the unilateral ability to decide what's best for every child, not doing what we do now when the parents abuse their children, neglect their children, or otherwise abandon their authority as parents. Then the government can step in and decide what's best for children. But until then, parents get the choice of what they think is best for their child. There's two arguments that the proponents of the treaty continue to make. And I would just love the fact checkers in the media to go check these facts, because they're just preposterous. If people wrote these facts down in my course in international law, I would flunk them, at least on that particular assignment. The first allegation is, if the United States ratifies this treaty, then Americans with disabilities, when we travel abroad, will suddenly find themselves with perfect accessibility wherever they go. Now, you just have to, you have to just suspend any knowledge of law to believe that. Because the American ratification, as a matter of international law and as a matter of American constitutional law, has impact only on the United States. America's ratification doesn't control the law in Germany or Spain or Switzerland. I was just, the day before the election, came back from a trip to Berlin where I was speaking at a global homeschool conference. And my son and I went into a lot of restaurants. I did not see a single restaurant in Berlin, Germany that was accessible for disabilities, not a single one. If they had them, they were not signed. The Burger King that I went into, there was a young woman in a wheelchair, and you had to go down this tricky flight of stairs to get there, and there was no obvious access. Now, let's assume that there was no secret compartment someplace that I didn't see and didn't know about. But if German restaurants or Swiss restaurants or restaurants in Zaire don't have handicap access, what impact would the United States ratification have on that? None. Germany's already a party to the UN, to this UN treaty. If Germany is going to comply with the treaty, it's going to do so because its own government decides to force restaurant owners to comply. The wheelchair ramps I saw were much steeper gradations than are the practice in the United States. Do you think the United States standards are going to suddenly apply in Germany if we ratify this treaty? You just have to suspend any common sense and any knowledge of law to make such allegations. And, you know, Germany's not going to build new wheelchair ramps, but also there's a kind of an implied idea that Americans, when we travel abroad, can't use the pre-existing wheelchair ramps because we haven't ratified the treaty. I mean, can you imagine the Burger King manager in Berlin denying an American the right to use whatever wheelchair ramps are there just because the United States hasn't ratified the treaty? It's utterly preposterous. Somebody needs to do fact-checking on the claims by the administration and the proponents here in the Senate. I guarantee you 4 Pinocchios. They would not survive any sense of credibility if you look at this. The other claim made by the administration, the proponents of the treaty, is that the treaty would not change American law. That's not true. They point to the reservations, understandings, and declarations, which has a non-self-executing provision within it, which means you can't go to court automatically. You must have implementing legislation first before you can go to court on various things within the treaty. If it passes in that final form, let's assume the validity of that reservation, understanding, and declaration. If that's the case, under international law, the number one rule of international law is keep your promises. There's actually a Latin phrase with it, but I never studied how to pronounce Latin, so I know I could write it down. But it means in English, keep your promises. And we have a duty, a legally binding duty, to pass legislation to meet UN standards. So just because there's a non-self-executing reservation, that excuses our courts from some level of action. But it does not exclude our responsibility to comply with international law. And if we want to set a standard for the world in international law, which is the overall theme of the administration on this topic, we need to set the standard on good faith compliance with our treaty obligations. We ought not to ever pass a treaty and say, yeah, we passed the treaty, but we don't have any obligations. This is going to be about other people in other countries, because that's the argument you hear. This is going to be about other people in other countries. We don't have to do a thing. That is not how you demonstrate good faith compliance with international law. You demonstrate good faith compliance with international law by only ratifying those treaties that you fully intend to implement as they are written, as they are intended. And if you do that, then that's a good reason to ratify a treaty. But when they're having to cross their fingers and dot, to say King's X to all this stuff and say, no, it really doesn't apply to us. It really only applies to Americans when they travel. That's a warning sign that something's amiss. Someone doesn't understand international law. I found it telling that in the Senate hearings, the experts coming to testify in favor of this were all experts in American disability law. They didn't bring over Harold Coe or somebody with expertise in international law, because if he's sworn to tell the truth, he'd have to tell them that what I'm telling you is accurate, that international law has effects. And it will change the law of the United States in several dramatic ways, including and especially changing the best interest standard to a state of affairs where every family with disabilities would lose their presumptive right to make decisions for their children, and instead that presumption falls to the state, just like it does in New Zealand. Thank you very much.
Okay, why don't we open up the floor to questions? Yeah. Okay, so as to your first question, you'd really have to speak to those groups as to what their theory is. I don't want to speak for them and try to articulate for them an argument with which I strongly disagree. But yeah, the bottom line is that ratifying this treaty doesn't change the law in Zaire or in Germany or in Switzerland. It doesn't, it can't. The fact that the U.S. might ratify it doesn't mean automatically that those countries are all of a sudden going to start honoring either their domestic laws that they might already have on the books, or that they might start taking more seriously commitments they may have made by themselves ratifying this treaty. With respect to your second question, if I understand it correctly, you're asking whether we could fix it, whether we could save it, whether the reservations or the other clarifying language that was discussed in committee might ameliorate my concerns. The short answer to that question is none of the clarifying language that they offered up and discussed in committee changes the underlying concerns that I've got. None of that eliminates the language about embracing obligations consistent with recognition of economic, social, and cultural rights, nor does any of that negate or undo any impact of the Article 7 best interests of the child standard.
I would just say in response to the first thing with veterans groups, Mike is right that nothing, passing this treaty does nothing to change the laws of other countries. The idea that by passing this treaty we're providing leadership and therefore other countries will also adopt it is undermined by the fact that they will not actually, as Mike said, follow through with implementing legislation to actually make this stick here in the United States. So in either effect, it doesn't provide any moral leadership. But to pass it, we provide the moral leadership by having passed already Americans with Disabilities Act and other types and spent enormous amount of resources, as we do in this country, to help people with disabilities be mainstreamed into economic and social life into America. And that's the example that we set. To sign on to some treaty that has problematic areas for people with disabilities, children with disabilities in particular, is not the answer.
If I could just echo one thing briefly about that. My mom has MS and has been in a wheelchair for a long, long time. And I've had the privilege of pushing my mom in her wheelchair around Switzerland, France, and Austria. There is no doubt that the United States is far ahead of any other nation in the world in accessibility. And if I believe for a moment that it would help my mom if she wanted to travel back to those nations for us to ratify the treaty, I'd do it. But it won't. It just won't. And I think that veterans groups have been assured by the State Department and others who know better. They understand how this really works. Harold Coe knows international law. And so to suggest that it would help them, I believe they've been misled. I think that the veterans groups, I think the world of their motives, their desires, their service to our country, their service to veterans after they've served our country, I think the world of them. But I think other people have told them that they would have access, and if it was true, it'd be wonderful. It's just not true.
Yes, during the lame duck I do, because we've got 36 signatures on my letter, and it takes, of course, 67 votes, 2/3, to ratify a treaty. So 34 votes for the no position are sufficient to block ratification of a treaty. We clear that threshold with 2 to spare. So notwithstanding Senator Reid's statement earlier today that he intends to move it forward, I don't anticipate that it will go anywhere. Yep.
Is there some type of sense that you may have that perhaps the Obama administration is looking as sort of a equal momentum for Obamacare?
I don't have that sense, Rick.
I don't have a sense for that particular provision, although I would say I do think it's a momentum builder for other UN treaties that are in line, the Convention on the Rights of the Child, CEDAW, and the ICESCR, the International Covenant on Economic, Social, and Cultural Rights, which has been languishing since the 60s because we didn't ratify it because, well, that was a Soviet bloc thing to do, to give those kind of social entitlements. And so to relate it to Obamacare, can't do it. But to relate it to those other treaties, there's no doubt that this is a warm-up act for those other treaties.
Thank you very much for coming. I appreciate you joining us.